I'm Jeb Butler of the Butler Law Firm. Some people wonder, how long do I have to file my sexual assault or rape case? In Georgia, the general answer is 2 years. In general, the Statute of Limitations, which means the time within which the case has to be filed with the court, is 2 years. That is the statute of limitations for personal injury cases, and most of the time, a sexual assault or rape case is a type of personal injury case. So it's governed by that 2-year statute of limitations, which is written in the Official Code of Georgia Annotated, or OCGA, section 9-3-33. And if you type this string into Google, if you want to look it up, it'll come up. There are some exceptions to that, and the first that we'll talk about is the one for minors. If a minor is a victim of sexual assault or rape, then that 2-year clock, that 2-year statute of limitations, doesn't start ticking until the minor turns 18, which effectively means that the minor has until he or she is 20 years old to file a case with the court. So for minors, it's normally 20 years old, and the statute for that is OCGA section 9-3-90, subsection C. Georgia has a relatively new law on the books that extends the deadline further for childhood sexual abuse. Now, when I wrote that on the board, I put childhood sexual abuse in quotation marks because that's a defined phrase under the statute. It means when certain listed offenses, certain listed crimes occur to someone who's under 18 years old, those can constitute, or those can be, childhood sexual abuse. And if that's what happens, then the victim has until he or she is 23 years old to file the case, or within 2 years after the victim learns about what happened, or learns about the way what happened has affected him or her. Now, that statute has some complexity to it. There are some limitations there. But in general, it says until the victim is 23 years old or 2 years after they learn about it. And the code section for that, if you want to look it up on your own, is OCGA section 9-3-33.1.